In state court, the process is similar, yet sometimes not so similar. In state court, most people that are arrested in state court are arrested on what they call a warrant, which is sworn out by the police officer or some victim, and then you go to court called General Sessions Court to see if there's enough evidence to continue charging you. You have the right to a preliminary hearing. Most people that are arrested in state court post a bond and get out on bond during the pendency of their case. Sometimes the bonds can be lowered. One problem I've seen sometimes that have hurt clients is that they're on probation for something else and they pick up another charge. One of the fastest ways to go to jail in state court is one of the fastest ways to go to jail and stay in jail in state court is picking up a charge while you're on probation. If you pick up a charge while you're on probation, you can make bond usually before the judge that puts you on probation decides that you violated the probation, but he'll pick you back up. So if you pick up a charge while you're on probation in state court, best thing to do is not make bond right away, but call an attorney and see if you can work out the situation, because I've seen so many people go in and spend hundreds of thousands of dollars on a bond, and then 2 or 3 days later, the judge that put that person on probation on the older charge issues a probation violation warrant, and that person is picked right back up and goes back into jail and is held without a bond. So you've wasted all that money that you paid the bondsman. In General Sessions Court, you have a right to a preliminary hearing. As I said, people want to know what a preliminary hearing is. It is a test to determine if there's enough evidence. And if you have a preliminary hearing, the prosecutor has to show the General Sessions Court judge that there's enough evidence to not convict you, but at least make it more likely than not that you committed the offense. And that is usually done by putting witnesses on the witness stand. A preliminary hearing is a good thing if you're fighting the case. If you didn't do it, you want a preliminary hearing, because what happens is the witnesses have to get on the witness stand and they have to tell the judge what happened. And they also are subject to my cross-examination. And I can ask them questions and find out if they're telling the truth or not sometimes. Sometimes they'll say one thing at a preliminary hearing and later on say something different. And that's not good for them. That's good for my client. If the judge finds that there's probable cause after a preliminary hearing, he'll send the case to a grand jury. They'll decide whether there's sufficient evidence, which they usually do, and then your case comes out of the grand jury process, and you have to go upstairs into criminal court to be arraigned on your charges, and you have a right to a trial in criminal court. That's the procedure in state court. Some cases take a very short period of time. If you are arrested, you could go to court and the prosecutor might make you an offer that will work for you and you can get rid of your case right away, or at least plead to something and get on probation. If you committed a felony, you can't plead to a felony in Sessions Court. You'd have to go upstairs in criminal court to plead to a felony, but sometimes felonies are reduced down to misdemeanors in the General Sessions Court level. There are many aspects to criminal proceedings and criminal process that would take too much time to go into, but you have a right, an absolute right to a trial by jury. You never have to testify yourself if you don't want to. You don't have to prove your innocence. The state has the burden of proving that you committed a crime beyond a reasonable doubt. So I'd be happy to talk to you more about it. Just give me a call. Thank you.